Petition number 15001-623. Today we're here for continuing bench trial on original petition for permanent custody. All parties please state your name for the record.
Kelly Legacy, Assistant Attorney General on behalf of DHHS.
Katrina Hayden, CPS investigator for DHHS.
John Giancotti from CHAP, guardian ad litem.
Adam Devlin, attorney for Alexander Dorsey.
Alexander Dorsey.
Good morning, Laura Anderson, P51285. I represent the father, Stephen Berry. Please state your name.
Stephen Berry.
Good morning, Your Honor. Janice O'Burns, 35185, counsel appointed on behalf of Mitchelle Blair, who stands to my right. Blair, I'm sorry. Stands to my right.
Mitchelle Blair, mother Gabrielle, and Matthew.
Good morning, Your Honor. Tracy M. Martin, 263745. I'm here as guardian ad litem for Ms. Mitchelle Blair.
Okay, everyone can have a seat. We set today's date for closing arguments and for decision by the court. We were last here June 11th, 2015, and we did complete everyone's testimony at that point, and along with any potential rebuttal by Ms. Legacy. But we did have a chance to have in-chambers discussion with the attorneys this morning. And we do have a preliminary matter that I did discuss with all counsel, but specifically as to you, Ms. Burns, and that is that the court did receive 2 different letters from the mother, and while the court doesn't specifically read the letters, and I did return them to you so that you would have them, the court is aware of two issues that the mother raises, one being her counsel, and 2 being that she wished to provide some testimony to the court. So, starting with her counsel, let's take that issue.
Thank you, Your Honor. Yes, I understand the letter Ms. Blair asked to have me removed as her counsel based upon the fact that I did not, and at the point until yesterday, could not call her as a witness. I stand ready to stand down if the court desires.
Anyone else wish to weigh in on that issue? I'll give you a chance, Mother, so you want to just check with the other counsel?
No, Your Honor.
Mr. Mason, Mr. Dugan.
Judge, other than to ask the court to obviously take judicial notice of what has occurred during this trial, Ms. Burns is one of the most capable and efficient attorneys in this courtroom regarding on these cases. I have nothing further to add.
And Mother, can you speak?
Yes. Basically, I don't deny that she's efficient and she's a good lawyer, but she did, in fact, violate my right to testify. Mr. Burns, I'm sorry, Mr. Harris, which is my criminal trial lawyer, was speaking directly to her, and as a direct result of that, she stopped me from testifying because she was basically thinking it was going to hinder something as far as me incriminating myself in my criminal trial, but I was explaining to her how much more could I incriminate myself if I've already publicly confessed more than 3 or 4 times. And my biggest thing to Ms. Burns was she kept giving me the runaround through all 3 dates of the testimony, the 3rd, the 4th, the 5th, and the 11th. I told her I don't care. Put me on the stand. She didn't. To me, she did not understand that I have a right and a say-so in my own defense. You get what I'm saying? She kept saying, oh, well, Mr. Harris doesn't think that it'd be a good idea if you get up there. And I'm saying, well, how else can the judge understand that Stephen Berry and Alexander Dorsey were never there for their children if they don't care for me?
Your Honor, I object to Mother's testimony regarding
But it's true.
We're not going to take any specific testimony, but your request basically is based on the fact that you wanted to testify.
Exactly.
And that's the main reason for your request for it.
And I was not being heard by her, so which made me not trust her as my lawyer. If I can't trust her as my lawyer, why are you my lawyer?
Okay.
Well, Your Honor, just the only thing I will put on the record is I heard her and I understood her. But I have an obligation as a lawyer licensed in this state to protect the client's constitutional rights, and that I did.
Your Honor, I also told her I understand what she has to do as a lawyer, but this is my trial. I'm on trial. My child I need to fight for. So everybody can understand on record how how they were truly as fathers. I also told her my daughter Gabrielle needs to be called to testify against them too. Why? Because of course nobody wants to hear me. They're not, in light of what I did, nobody's going to believe me, and I do understand that. So my daughter Gabrielle is 17 now. She is the only one other than me that knows in total detail and witnessed everything that went on with Stephen Berry and Alexander Dorsey and how they weren't there. So I would definitely want her to be called.
Let's just take one issue at a time. So, okay, on issue number one, the main problem is that Ms. Blair wanted to testify. There really are no other issues with Ms. Burns' representation. As indicated, Ms. Burns certainly has a wealth of experience in these kinds of matters. So, with respect to the request for a new attorney, the court's going to deny that. We are well over 2/3, 3/4 of the way through this trial. And so to start over would just be foolish at this point. So the court was going to deny the request for a new attorney. But our second issue is the mother's request to testify. So, Mother, you have a seat for a minute. Let me just hear from Ms. Burns first. Ms. Burns, I know that she wants to testify. Can you give us an offer of proof as to what issues the mother's testimony would go to?
Well, the offer of proof is basically just what Ms. Blair was saying to the court. She wishes to testify with regard to the issues of Mr. Berry and Mr. Dorsey in terms of what was said from the stand and what has not been said from the stand, in terms of the fact that her testimony would be that they were not there, that they had never been there for their children, that they have issues in terms of conduct and character that would go to jurisdiction.
Does any of her testimony go to the question of whether or not the court has jurisdiction over the two children, or whether or not the court has a statutory basis to terminate specifically mother's rights, leaving the fathers to the side?
As I understand the court's question, the court is asking whether or not any of the testimony that Ms. Blair will give goes to her actions towards jurisdiction.
Whether we would have jurisdiction through her, or whether we would have a statutory basis to terminate her rights.
It would be only in combination with the behaviors and character flaws that I indicated she would testify to for Mr. Berry and Mr. Dorsey, along with herself, in combination.
Anyone else wants to weigh in? Let's start with you, Ms. Mason.
Judge, we had a discussion in chambers about this. As the court indicated, the only party that could potentially be prejudiced by mother testifying at this point would be the Department of Health and Human Services, because we are the only party at this point that can call rebuttal witnesses, and as the court indicated, mother would have been one of the last witnesses. I don't have anything further to add than that.
Mr. Diaz.
I have nothing to add on this, Your Honor.
Mr. Devlin.
I would just say that her job is not to prove the petitioner's case, to establish the burden of proof. Her job is to defend herself. If she's going to be offering testimony that is going specifically towards my client's statutory grounds for termination, I don't see how that has any relevance to the reasons that she was not called as a witness to convolute her criminal trial. She could have got up there at the time, and I request that we deny her to be a witness.
Thank you. On behalf of Mr. Berry, I agree and adopt into my response his response, but I would add that Ms. Blair did have the right to testify at this trial. She could have testified as to her position regarding the fathers. That would not have incriminated her. This is a civil matter. She could have been called. I would have objected to her testifying to such. It doesn't go towards anything having to do with whether or not her rights should have been terminated. And further, Ms. Blair is free to testify at the best interest hearing. So she will have an opportunity to provide information she wants to the court regarding anybody related to this case. So if there was an error in her not testifying, it's harmless. The court already has Ms. Blair's written statement entered into evidence in which she admitted killing the children. Ms. Blair reminded the court today that she also admitted publicly several times prior to closing the case that she's killed the children. So clearly there are grounds as to her. From her attorney's own statements, she's not wanting to testify at this phase, having anything to do with grounds against her, it really goes towards best interest to the father, Your Honor. Thank you.
Well, I will just respond to Ms. Anderson, Your Honor. First of all, she would not have had a right to object to the mother testifying and a right to object to any cross-examination that I made if I had chosen to call her as a witness in terms of if that was against the father or if it was against the mother. So that is something that is non-plus in terms of an argument. With regard to, yes, mother still has an opportunity and a right to testify as to best interest. But Ms. Blair has indicated to this court and to myself that she wishes to have her proofs reopened so she can take the stand and make her statements and her testimony. I have given the court an offer of proof based upon what my client has said even this morning as to what her testimony will be. Obviously, it will be against the two fathers. Obviously, it will also be against herself.
Okay, thank you, Ms. Burns. The issue is, with respect to Ms. Blair, is that certainly if you raise the issue that you had a disagreement with your attorney regarding the progression of the case, if the testimony that you did not have an opportunity to offer went as to your side of the case, and it's some bearing on your side of the case versus bearing on what the court should do with the fathers, the court would likely reopen the proofs. And of course, if the court had to do that, then it would have to give the agency an opportunity for rebuttal because they already passed up on their opportunity for rebuttal. But given that, as indicated by the offer of proof, that the testimony that you would offer would not necessarily go to the questions that are on the table regarding you today. And as we indicated before, there are multiple questions in these type of cases. The two questions that are on the table regarding you today are, one, does the court have jurisdiction or temporary custody over your two surviving children because of your actions? And number two, then does the court have a right to terminate, authority to terminate your parental rights based on your actions? Those are the two questions relating to you. In your testimony, if the court were to reopen it at this point, would not go to those issues. I would agree that perhaps if we get to a best interest hearing, depending on the outcome after today's closing arguments in the court's decision, that if we get to a best interest hearing, perhaps your testimony would be probative on the best interest questions, depending on which parents were deciding about at that point in time. But in terms of the statutory basis of jurisdiction, the court doesn't think that your testimony will change or have any relevance to those questions. So I'm going to deny your request for today. If you wish to testify, and if we get to a best interest hearing, then the court will entertain that on July 27th. So that's the court's view.
Can I say one thing?
Speak to your
Should it be hard?
Speak to your attorney first.
He wants to know what you want to say. Yeah, and for the record, what Ms. Blair wants to make a statement is regarding it was a jailhouse recorded conversation between she and Mr. Berry.
And he indicated that he was definitely going to lie.
The court, like I indicated, the court, if we get to best interest hearing, the court will entertain that testimony. It appears that it's more of a best interest question than it is a statutory basis question. So the court will allow you to raise that request again if we get to a best interest hearing on July.
What about my daughter?
Once again,
The court pierces, you haven't heard anything, you have not heard the truth about Alexander Dorsey or Stephen Berry. So I'm actually requesting take a polygraph test about both of them.
You can speak to Ms. Burns about it, but once again, those are issues that would come up for best interest. They don't bear on the two questions that the court has to decide regarding your case today. So if we get to best interest hearing, you can discuss that with Ms. Burns, and the court, of course, will allow you to present that testimony at best interest, depending on which parents are involved in the best interest. Okay, so that's now. Any other preliminary matters before closing?
Yes, Judge, before we get to closing, I did tell Ms. Burns that it's been addressed peripherally. I would ask for a stipulation that as of yesterday, Ms. Blair did in fact tender a guilty plea to felony murder and premeditated murder in regards to Tony Blair and Stephen Berry.
Obviously, Your Honor, with the amount of coverage on that, there was a plea made before Judge Dana Hathaway yesterday. My understanding that the sentencing is not until July 17th before Judge Hathaway. So, I mean, the fact that she made the plea, yes. Actually, and the court accepted it. There has not been a sentencing, so she can do it. She can withdraw it even until the 17th. So I can stipulate that it was made. There hasn't been a sentencing yet.
And the court did not accept the plea at this point?
The plea was accepted, but there's been no, I would agree there's been no conviction per se because she hasn't been sentenced yet. So that's the reason I'm not seeking to amend the petition to include those statutory grounds regarding incarceration for 2 years or convicted of homicide, because there is no conviction technically in the criminal sense until there's been a judgment of sentence.
Exactly, Your Honor. So that actually at this point, the fact that she has made a plea really doesn't change what would be or could be the basis of this court's jurisdiction with regard to Ms. Blair.
Right. That's true. So the court, if you wish to introduce that, it's our best interest hearing. If we get to that point, you could certainly introduce that on the July 27th. Apparently the sentencing on the criminal case will be done at that point. I don't think it's probative at this point.
It's just another admission. It's just a stipulation I wish to have for the record. And secondly, in terms of Mr. Berry, I told Ms. Anderson that for clarification of the record, we would stipulate that at the time of Stephen Berry, the child's murder, Mr. Berry, his father, was in fact incarcerated in the Department of Corrections, released in April of 2013. I told her I'd make that stipulation.
Well, that was set forth by the testimony.
Right.
When he testified, he indicated he was incarcerated from December 2010 to April 2013.
Right. I just wanted the record clarified in terms of my agreement with that stipulation.
Any other preliminary matters before closing arguments by anyone? All right, I'll start with you, Ms. Brady.
Your Honor, as the court has just stated, we're here today for the court to decide, to make decisions regarding two things: jurisdiction and statutory grounds for termination. The facts of this case are obviously horrifically unique to these children, to this family. The reality, however, is that the abandonment, the brutalization of children is not new. It's not unique to this court. Because on a weekly basis, this court is seeing and hearing cases of abuse and neglect. Varying levels, varying degrees. And the court makes decisions regarding its involvement, regarding termination of parental rights on a weekly basis. And I bring that to the court's attention because in this case, because of the facts, there has been obviously a lot of media attention. There has been a public interest in these children in this case. But I'm addressing this because my burden, the Department of Health and Human Services' burden in regards to jurisdiction, in regards to termination, is not increased, it is not altered, it's not heightened. It remains what it is on every other case of abuse and neglect, termination of rights. And that's to prove by two different standards of evidence: preponderance of the evidence with respect to jurisdiction and clear and convincing evidence with regards to statutory grounds. In regards to the first issue, I would submit to the court that it's irrefutable, it's beyond a preponderance of the evidence, that this court has jurisdiction with respect to Gabrielle Blair and Matthew Berry, in regards to Mitchelle Blair, Stephen Blair, and Alexander Dorsey. It's irrefutable that based upon either the action or inaction of these three individuals, that those two children were at risk of harm at the time the petition was filed. That those two children were without proper care and custody, and that those two children, their home or environment
was unfit. We move on then to statutory grounds for termination. And in this case, with respect to Mitchelle Blair, in the petition, there are 9 specific grounds alleged. 6 subsections under K itself. With respect to Alexander Dorsey and Stephen Berry, there's 4 specific sections discussed or proposed. Mitchelle Blair, Alexander Dorsey, and Stephen Berry, in terms of statutory grounds for termination, however, share 2 grounds, 712A.19B3G and J. And as this court knows, what those sections essentially say is that because of these 3 individuals' separate action or inaction, acts of commission or omission, that these children, Gabrielle Blair and Matthew Berry, are subject to a substantial risk of harm if they're returned to any of these individuals. That these 3 people do not have the conduct or the capacity to parent Gabrielle Blair or Matthew Berry. And I bring that to the court's attention, these 2 common grounds, because it's important to recognize that all 3 people, Mitchelle Blair, Alexander Dorsey, and Stephen Berry, are culpable. All 3 people are responsible for the abuse and neglect, for the trauma, for the torture and ultimate murder of at least 2 innocent children.
2 rapists.
What's important, and I recognize, Your Honor, with respect to Mitchelle Blair, with respect to this case, I recognize that there is only one person that is directly responsible. One person who tortured, terrorized, brutalized 4. All 4 innocent. All 4 innocent children.
2 rapists.
4 innocent children, 2 of which were murdered. I recognize she is the person directly responsible. And as I sat here trying to prepare this argument, thinking about what to say to this court, so many thoughts and emotions went through my mind as a lawyer, as an advocate for the department, and as a human being. Because as a human being, you want Stephen Berry and Stony Blair to have a voice. When you reflect on the agony, on the pain that these children suffered, you want them to have a voice. So you have this desire to stand before a court and denounce this woman and her actions. But in going through my argument and thinking about this case, and Mitchelle Blair in particular, I realized that that was not necessary. It's not necessary to spend additional time on Mitchelle Blair.
That's right, because think about what my son went through when they was raping him. Think about how he felt.
Because there is no way of bringing these 2 innocent children back. There is no way to repair the damage that has already been done to Gabby and to Matthew. You can't just hit the reset button. So what you have to do is you have to step out, take yourself out of that emotional abyss that you want to fall into when you think about the facts of this case, and you look at the law, you look at this case objectively. So you come back to the statutory grounds with respect to Mitchelle Blair. 9 of them. And they deal with, as outlined in the petition, 712A.19B3BI, the parent's act caused a physical injury or physical abuse, and there's a reasonable likelihood of the same in the future. G, the parent without regard to intent failed to provide proper care and custody. J, the children are subject to a substantial risk of harm if returned to her care. And then you have K, and you have 6 different subsections. That the parent, Mitchelle Blair, abused the child or sibling, and the abuse included, in this case actually it would be 5 sections, Your Honor. Battering, torture, or other severe physical abuse, which is K, III.
loss or serious impairment of an organ or a limb, life-threatening injury, murder or attempted murder, aiding and abetting, attempting to commit, conspiring to commit, or soliciting murder or voluntary manslaughter. It goes without saying this court heard clear and convincing evidence that Mitchelle Blair repeatedly, over a period of time, terrorized and tortured her children. The court heard this through her own written statement, through the medical examiner's testimony, the photographs that the court has, through the medical records admitted. The evidence is clear and convincing that all of the statutory grounds alleged with respect to Mitchelle Blair have been met. With respect, then, we move on to Alexander Dorsey and Stephen Berry, the fathers of these children. And I use that term loosely, and I ask the court to do the same. Because when you examine the definition of fathers, of a parent, in the legal sense, not the emotional, not the moral sense, in the legal sense, you find certain words. You come across certain words when you look in terms of case law and defining a parent and what their role, their duties are. You see words like involve, support, provide, care, consistent, contact, protect. The court heard the testimony. The court has the exhibit. None of those words can be associated or attributed to Alexander Dorsey or Stephen Berry. What instead the court finds through clear and convincing evidence through their own testimony is that the words that should be, in a legal sense, associated with these men are words like abandon, desert, forsake, relinquish, ignore, avoid, surrender. Because that is what these two men did with respect to their children. They surrendered them to Mitchelle Blair. They engaged in no attempt to demand a right in their children's lives. And that is why you have 4 sections, 4 statutory grounds with respect to Alexander Dorsey and Stephen Berry. That being 712A.19B3B A-II, which is the desertion, B, III, which addresses the failure to protect, and G and J. What the court can find in terms of commonalities of arguments for both of these individuals, Alexander Dorsey and Stephen Berry, is that both of these men abandoned their children, the 2 deceased and the 2 surviving. And I realize that it's the 2 surviving that are subject to the petition, and that's where the desertion applies to. And that because of this desertion, these men failed to protect their children from Mitchelle Blair and from her actions. And that as a result of this desertion and this failure to protect, these children are at a substantial risk of harm if returned to either of these men. And that as a result of this desertion and this failure to protect, neither of these men have the conduct or capacity to parent their children. And what did the court hear in terms of evidence regarding the desertion ground? Well, the fathers themselves admitted that well in excess of 91 days, they had not had contact with their children. Financially, physically, well in excess of 91 days. That ground has been met through clear and convincing evidence. What the court also heard with respect to both of these men, and as a result of their complete avoidance of their parental duties, is that they did in fact fail to protect
their 2 murdered children, and their surviving children. I recognize, per that stipulation, that Stephen Berry, at the time of his 9-year-old son's life, at the time that life was taken, was incarcerated in the Department of Corrections. I submit to this court that that does not absolve him. His own actions put him in prison. His own criminal behavior took him out of his son's life.
He wasn't in his son's life even before he died. You know it.
Ms. Blair, stop.
I'm just,
You'll get a chance. Ms. Mason.
And I would submit to the court that what history shows, or what Mr. Berry's own testimony shows, is that had he not been incarcerated, he likely would have had no involvement in either of his children's lives. Because after he was released, he had no contact with his children. None. Obviously, he couldn't have contact with Stephen because he had been murdered, but he never even took actions to verify that his son was alive. Which brings us to Alexander Dorsey. In contrast to Mr. Berry, who was in the Department of Corrections at the time his son was murdered, Mr. Dorsey was out living when Stoney was killed. Those were his words. He was living. He was eating. He was sleeping, not being abused, beaten, starved, burned, scalded, going about his own life while his daughter was being tortured. And you know from the testimony, from the evidence in this case, that not only did these men fail to protect their murdered children, they failed to protect their surviving ones. And how do we know that? The court knows that because the court has, as evidence, had the Kids Talk DVD, has the medical records where Matthew and Gabby state that they themselves were victims of abuse. They themselves were beaten repeatedly by their mother. They were burned, Gabby in particular, with an iron, hit with a 2x4. Matthew beaten with belts or cords. And fathers say, there's arguments, I expect, well, they didn't know that was going on. You know, this is not a criminal case, and in criminal cases you use the words reason and common sense, but those same principles apply in every case. Reason and common sense. These are 2 men who knew Mitchelle Blair for over 10 years. Mitchelle Blair, who in 2002 and 2005 had contact, admittedly with protective services, because of the physical abuse of her children. Reason and common sense tell you that these men knew she was unstable, that she had violent tendencies. Reason and common sense tells you that you don't know what someone for 10 years and you have no idea that this is occurring. Even her neighbors knew. Those were their own witnesses. But because they could not be bothered with their children, bothered with verifying their physical well-being, and I say this because they couldn't. That's the facts, Your Honor. And I sit here and I'm wondering, why am I even making these arguments to convince this court that their rights should be terminated? They did not even care to see, to verify their children's faces, Stoney and Stephen. What kind of parent doesn't need to verify that their child is physically alive? That is content to go through every single day saying, I'll take her at her word. I don't actually need to see or speak to my child to verify his or her well-being. A parent who doesn't care, a parent who is absent, a parent who doesn't have an interest in actually being a parent in the true sense or the legal sense of the word. What is so unfortunate in this case for all of these 4 children is that not only was one father, but both fathers were absent.
Because had one of them cared enough, this court may not be here today. Cared enough to demand, I want to see my child. I want to know that he or she is okay. They were content to sit on the sidelines and do nothing. And that speaks to their conduct and capacity to parent their children. They did not have to be a witness to Mitchelle Blair beating their children. All they had to do was be involved. See their children consistently. Don't abandon them. Don't desert them. They chose, not under any type of duress. They are adult men. Adult men who knew how to get to this court, who now say or know how to call 911, who have their own experience, at least Mr. Berry, with the criminal justice system, the court system, enough knowledge to make phone calls. They chose not to do so. These children, all four of them, deserved so much more from their fathers. They deserved someone who cared enough to, at minimum, and I'm not talking about an ideal, perfect parent, at minimum, verify that they were alive. How can someone have the conduct or capacity to parent their two surviving children if they didn't care enough to do that with the two murdered? What I submit to this court with respect to each of these parents, and again, that term is used loosely, all of the statutory grounds based upon the evidence, which would include the testimony and the exhibits, shows that, number one, there is grounds absolutely for jurisdiction and grounds for termination. I submit to this court, I ask this court to find a legal basis to show Gabrielle Blair and Matthew Berry that they in fact were deserving of so much more. By finding that there was clear and convincing evidence that these parents, that these fathers, that Mitchelle Blair should no longer have a right to parent either one of them.
Your Honor, as the court knows, my job as the guardian ad litem is to make a recommendation based on what I see is best for the children. And many times I can agree or disagree with the Attorney General, and in this case, it keeps coming back to me as I'm listening to Ms. Megacy's argument. I could just say ditto and be done, but I guess these children deserve so much more than that, and I think it's important that the court recognize from what I think is in their best interest and how this all plays out, based on it all comes back to the facts. And we start with this case, and the question that came into my mind when the case first started was, how do you not know your kids are dead for in excess of a year? And I guess I'm going to start with the fathers, because to me, it is reprehensible as to what the mother did. Being a parent is when I represent parents, sometimes I say the child is the center of your universe. And for you to have that child, they have to be the center of your universe. And in this case, all three parents did not have this child as the center of their universe. And taking that premise, we have to look to the law and the facts that we have in this case. Certainly, based on the entirety of the evidence, I do not see how the court could not take jurisdiction over all three, as to all three parents. I mean, it's clear these children were without proper care and custody based on any interpretation of the evidence. You can't come to a conclusion other than that they were without proper care and custody. So certainly I believe that the court can find jurisdiction. As it relates to statutory grounds, I look to the parents, and to me, Mr. Dorsey's testimony that he was 15 minutes away just stays with me this whole case. That he was 15 minutes away from this family with 4 children, 2 of which were his, and he didn't know. He had his head in the sand. He just didn't know what was going on. There's a lot of excuses, a lot of reasons on things he was doing, a lot of blame game going on against the mother, Mitchelle Blair, but he's a parent to those children. And he was 15 minutes away, and 2 children died, one of which was his, and the other child was a sibling of his children. And to me, you know, there was so much he could have done, whether we go through the whole litany of testimony, paying support, being involved in the kids' school, seeing the children. I mean, the gaps in time where there was no contact with the children, and even going back to 2005 when he was aware there was physical abuse on his children, and nothing happened. He had 10 years of all kinds of fire, flame, warnings, and he didn't do anything. So certainly he was there under the grounds that apply to him under A, I believe 19B3A, the child was deserted. Under B2, he certainly had the opportunity to prevent physical injury and failed to do so. And there is a reasonable likelihood that the child would suffer injury or abuse in the foreseeable future. The child was placed with him. I believe, based on the entirety of the testimony, that's there. Under G and also J, I believe those provisions are met as well. You know, absent parent, having your head in the sand and not being there for your kids is no excuse. Even if you don't like the mother, even if you think the mother is controlling, even if you think the mother has these kids locked in their house in their own prison, if that's how he wants to interpret it, he didn't do anything. You don't, and when it's your child, you have to do something, and he failed. And for those reasons, certainly there's statutory grounds against Mr. Dorsey. As it relates to Mr. Berry, his situation isn't a whole lot different than Mr. Dorsey. The last time he spoke or saw Stephen was 2010. That's years before the child was killed. He didn't even know his own child was dead. So certainly that's concerning, and in the most sick sense, also having only paid $63.98 in child support for his children. It shows that he wasn't involved. He didn't have anything to do with the children's school. His current testimony is that he has no housing. Even if the court were to consider him fit as a parent, he has no ability to support Matthew. He has no involvement in the child's life, school, medical. And the one thing I will give him credit for is he did indicate that he felt it was partly his fault in failing to protect. I mean, it's good that he had some insight to recognize that, but at least he did point that out to the court. But it doesn't excuse it. It doesn't warrant him getting a chance in this instance. I would submit to the court that the statutory grounds, the same 4 as it relates to him, are all present in this case, and the court can find those statutory grounds against Mr. Berry as well. As it relates to the mother, certainly the testimony is clear. There's evidence indicating that she killed 2 of her children. That in and of itself suffices to show there are statutory grounds, but beyond that, the other factors that are shown under K, there's little triple I, 4, 5, and 6. Those sections are all met. G and J are met, and under B1, certainly the evidence overwhelmingly supports all those statutory grounds, and the court should find those. So I would ask the court to, 1, take jurisdiction, and 2, find statutory grounds as to all 3 parents for the reasons I stated.
There you go. Good morning, Your Honor. There's 23 days left. This case has been many things over the past weeks, but now it boils down to 2, testimony and evidence. The standard at which the evidence must have been brought in order to find my client failed to protect and deserted his children is clear and convincing. The burden of proof is on the petitioner to show that all the evidence admitted clearly and convincingly proves my client abandoned his children and failed to protect them. We could have not called any witnesses and offered no exhibits because we are not mandated to defend ourselves beyond letting the petitioner fail to prove their case, because the truth, as corroborated through testimony and evidence, is that my client did not abandon his children and did not fail to protect them. We heard testimony regarding my client's visitation and presumed abandonment of the children. The only three people who testified to my client's visitation were him, Ms. Barnett, and Mr. Berry. All three of these people testified that he visited his children with some regularity and brought food and living essentials with him to assist in the raising of his children. For the time periods Mr. Berry and Ms. Barnett had personal knowledge of, their testimony supported and verified the testimony of my client's physical involvement in his children's lives, the very antithesis of abandonment. The petitioner has attacked his credibility, getting them hung up on dates and times of visitations. How often over a given period of time did he visit? And what part of the house were you visiting? Did you see certain evidence of abuse on them? I cannot remember how often I saw my mother in 2006 or 2010 with the specificity that the petitioner assumes is required to defend against abandonment, because nothing noteworthy occurred in those mundane, regular visits we had. It is the same with my client. Fatherhood is not about one or two moments in time, the amalgamation of his visits into a spectrum of memories that have all run together. My client doesn't have a journal of all his visits because he never thought he would be in a position where the exact details of one visit 7 years ago may cause the termination of one of his most guarded liberty interests in United States jurisprudence, the ability to parent one's children.
Your Honor, he went years without seeing these kids. Don't y'all know Gabrielle gonna get up here and tell the truth about y'all?
The burden to prove abandonment is on the petitioner, and my client's accounting of his visitation, corroborated by Mr. Berry and Ms. Barnett, is the only piece of evidence admitted that speaks to this element. There is no testimony that contradicts my client's testimony, and my client's inability to remember with pinpoint accuracy a set of unremarkable encounters over the course of a decade, despite corroboration by other witnesses, does not rise to the level of clear and convincing. The petitioner has failed to reach its burden, and the court must find that Alexander Dorsey did not abandon his children. The petitioner also states that he failed to support his children financially. Ms. Blair's attorney questioned my client as to when his last payment for child support was made, and he did not know. The truth is my client does owe. A month. Taken at their hypothetical maximum, that's $54,000 over the course of 5 years. And this maximum hypothetical, 1/4 of his income went to his children. When you factor in taxes, vacation, hourly fluctuations from week to week, and he may even work less than those 5 years, the percentage of income that he gave officially through the Friends of the Court gets even higher. This doesn't even account for the food and living supplies that my client, Mr. Berry and Ms. Barnett, testified that he brought with him during his visits. While maintaining employment was difficult for my client, it cannot be said that he did not do his best to support his children given the circumstances, and the evidence and testimony proves this. Mr. Dorsey did not fail to protect his children. In 2005, a report was made for abusive behavior against Ms. Blair. This report was made by my client and his family when his sister observed signs of abuse while bathing them. The petitioner got involved, and after the case was substantiated, recommended services and a plan for Ms. Blair to help her with her discipline of the children. At that time, everyone associated with the children, whether it was my client, Ms. Barnett, or even the petitioner, thought the services provided had changed Ms. Blair. The 2005 report even states that the risk for subsequent abuse was low. Since that encounter, testimony shows that my client never was alone with the children. Their mother was always with them, exerting an aura of fear and control. She knew I wouldn't tell. That was the testimony of Matthew Berry during his forensic interview when asked if he would tell anybody about the abuse. He didn't say no. He didn't say, I don't remember telling anybody or giving a big.
Because my sons knew he wasn't going to tell because he was happy that I killed them. They were his rapists. When my daughter Gabrielle get up here, she don't tell the truth and all y'all be looking stupid. You know they wasn't here for them kids.
Let the record reflect the mother requested the team's film.
He didn't say no. He didn't say I don't remember or give a vague response to the child. He gave an indoctrinated response based off an understanding of his consequences if he told anyone. How could my client know anything when the children were under such a spell? There was no flame, there was no fire, there was no smoke, and there was no suspicion. No evidence has been entered that anything was said to him, that he saw anything or found anything to be amiss. And the evidence that has been entered, that when he and his family previously found evidence of abuse, they reported it. The same indoctrination was offered by the testimony of the neighbors, who saw Miss Blair, Gabrielle, and Matthew routinely. Never did they think anything was out of place. Never did they suspect abuse on the part of Miss Blair. Never did they think it was strange they did not see the other two children, and not once was their trust in Miss Blair as a good parent questioned until they found the bodies. The medical examiner testified that the only external evidence of abuse that was not paramortal were healing scars on their extremities. We all have scars, and their mere existence does not give rise to the evidence of abuse and can easily be explained by the rambunctious nature of children. Ms. Barnett, a registered nurse, is a mandatory reporter, and she testified that she never observed any injuries that led her to believe that there was any abuse occurring despite her knowledge of the 2005 substantiated abuse. She further testified that the children were always clothed in long pants and sleeves, covering these injuries. Ms. Blair knew what my client would do if he saw the injuries that appeared to be abuse on the children because he had done it before. He would report her so that she hid it constantly and maintained her presence during all the visits to ensure no secrets were told. The petitioner believes my client should have done more. Despite no working knowledge of the legal system and a distrust for the police, as he testified they knew nothing for him, he should have guessed that there was abuse. Despite petitioner's objection to the relevance of the 2005 report, my client was put on permanent notice that the abuse was going to happen in the future and sentinel vigilance was required. Despite the fact that the petitioner and everyone around Ms. Blair believed that the services provided to her to discipline her children properly were working, my client was to remain eternally skeptical. Despite the risk being low, my client needed to be on high alert constantly. These arguments are entirely based on hindsight. My client, he was told that he could make a wellness check on the children, yet the petitioner had to explain to him what a wellness check was. My client was to demand that his teenage daughters strip before him so he can inspect their bodies to look for signs of abuse. My client was to violently push Ms. Blair aside and storm the apartment to search for stoning. These all seem like wonderful ideas in hindsight, despite all evidence to the contrary, as he had no proof that there was any abuse. He may have stopped something, he may have stopped something from happening that he never should have that he never had any evidence of. Suppose my client on May 25th, 2013, came to Ms. Blair's apartment, physically pushed past her despite protestation, ran to the freezer, opened it, found it empty, ran upstairs and found Stoney unharmed, and then after searching her, found no signs of abuse. This is a felony. Yet this is the expectation of the petitioner despite all evidence to the contrary. There's no evidence of abuse offered by the petitioner that my client should have known about to give him reason to suspect his children were in danger and needed protection. The entire claim of failure to protect is based entirely on induction. How could my client have missed this? Petitioner has asked my client repeatedly why he did not go to see Stoney after her disappearance, but fails to state the truth. If we change the previous hypothetical and my client finds both children in the freezer, he would still be here before Your Honor. He would still be here in this court. He would still have a petition to terminate his parental rights because the facts wouldn't have changed for why he would be here. The evidence relied upon by the petitioner to prove failure to protect is a failure to understand how my client could not see through the lies of Ms. Blair when the testimony and evidence proves that the order of control was so absolute that no one had any idea anything was wrong. How could anyone protect against not merely the unknown, but actively hidden facts that are undetectable by reasonable visitation, observation, and conversation? It is all reactionary hindsight, and it does not rise to the level of clear and convincing evidence that Alexander Dorsey failed to protect his children. It is impossible to fail to protect someone from something they never knew existed. Your Honor, if the evidence does not prove abandonment or failure to protect clearly and convincingly, then the only reason we can be here is because of public bloodlust. The gravity of what has occurred to these children at the hands of their mother is so great that it has sucked both fathers in. The public, media, and judicial outcry over this matter is so great that the punishment of the mother is not enough to sate them. To punish my client, however, for the actions of Ms. Blair is contrary to the one-parent doctrine. The one-parent doctrine is clear that my client must be judged by his actions and not those of the mother. If you take away the actions of the mother, the evidence against my client absolutely does not rise to the clear and convincing threshold needed to prove abandonment and failure to protect. Lastly, Your Honor, there is no accomplishment for finding statutory grounds for termination in this matter for Mr. Dorsey. The burden of proof was on the petitioner, yet the evidence and testimony clearly and convincingly proves the reverse. The fundamental notions of fair play and substantial justice lead us to the clear conclusion that he did not fail to protect and he did not abandon his children. Yet due to his living arrangement, the living arrangement to my client and his current employment status, we ask the court to take temporary custody of Gabrielle Blair until she reaches the age of majority in lieu of finding jurisdiction on statutory grounds. Thank you.
Okay, Ms. Anderson?
Your Honor, at the start of this case, I spoke of a parent's fundamental liberty interest in their parental rights. It's one of the oldest and most important rights a person has. For the court to sever those rights, it is the petitioner's burden to prove jurisdiction and by clear and convincing grounds for termination. A parent has no burden of proof in these cases. Further, the Michigan Supreme Court made clear that the court must treat and adjudicate each parent separately from the actions of the other, meaning the court could terminate one parent's rights and return the same child to the other parent immediately, or the court could find temporary wardship appropriate for the other parent and offer that parent a treatment plan with the goal of reunification between that parent and child. With Mr. Berry, the evidence only supports temporary custody as to Matthew due to his income and housing issues. Despite the passionate arguments made by Petitioner's Counsel and the Children's Counsel, the agency has failed to prove grounds for termination of Mr. Berry's rights. Throughout this case, the court has heard evidence of horrible abuse. Abuse perpetrated by Ms. Blair and Ms. Blair only. The court heard Matthew testify bravely regarding witnessing his mother kill Stoney and Stephen. The court has mother's own statements to the police confessing to killing them and whipping all of her children as a form of discipline. There are no allegations that anyone other than Ms. Blair abused the children. Certainly no allegations that Mr. Berry abused his children. The case against Mr. Berry involves allegations of abandonment and failure to protect, alleging that he knew or should have known of the abuse and could have prevented it. The petitioners failed to prove by clear and convincing evidence these allegations. The petitioner's only witness to prove its case against Mr. Berry was Mr. Berry himself. As much as the petitioner would like to try this case in hindsight, that is not appropriate. In attempting to prove the case, the petitioner and child attorney inappropriately uses the words of a grieving father who, like most parents in hindsight, would feel guilt and wonder what they could have done to prevent such horrendous harm to their child. In deciding this case, the court must consider not what we all know now, and frankly some even have a hard time believing such terrible things could have happened, but rather the court must consider Mr. Berry's situation and knowledge at the time. In order to do that, I start with what makes the most sense to me, Your Honor, and that's chronologically. I'm going to break down the years into 3 time periods. First being prior to Mr. Berry's arrest and incarceration in October of 2010. The second time frame being the 2.5 years of continuous incarceration from October of 2010 through April of 2013, and the third time frame being after his release until March of this year. The facts are, Your Honor, that in 2003, shortly after his 20th birthday, Mr. Berry's first son with Miss Blair was born, Stephen. Mr. Berry lived with Miss Blair before and after Stephen's birth. In fact, he testified that he lived with Miss Blair multiple times over the years, living a period of time with each of his sons, Stephen and Matthew. Matthew being born 3 years after Stephen when Mr. Berry was 23 years old. Mr. Berry testified that when he was not living with his sons, he visited them regularly. There is no testimony to contradict this. He testified that he supported them while living with Miss Blair and on his own. Mr. Berry, with a 10th grade education and a felony conviction from 2005, did find it difficult to find employment. Recall that until recently, for the last several years, the country, and particularly Detroit, suffered from a recession, making it difficult for many to find jobs. Mr. Berry himself was receiving food stamps. He did support his sons by giving them diapers, food, and clothing. Prior to his incarceration in October of 2010, Mr. Berry never saw Miss Blair being abusive to the children. He never saw marks on his children. The children never disclosed any abuse. The children appeared healthy and well cared for. Mr. Berry knew Miss Blair to be controlling and a yeller, but not a physical abuser. Further, the petitioner has failed to present any evidence that either of Mr. Berry's sons, Stephen or Matthew, were physically abused prior to October of 2010. The petitioner, in fact, failed to put forth any evidence in its case in chief that Gabrielle and Stoney, Mr. Dorsey's daughters, were abused prior to October of 2010. It was through father's cases in chief by questioning the petitioner that in fact the petitioner knew of Miss Blair and her tendency to abuse her daughters, Gabrielle and Stoney, for at least the last 13 years. Child Protective Services worker Miss Hayden and reports that were admitted confirm a 2002 and 2005 substantiated referrals of physical abuse on Gabrielle and Stoney, including school truancy in 2005. Ms. Hayden confirmed in her testimony that Child Protective Services never spoke to Mr. Berry. And the reports list Mr. Dorsey as the father of all 3 children, including Stephen, who was approximately 2 years old at that time. Attempts by the petitioner to show any evidence that Mr. Berry knew of the abuse on Gabrielle and Stoney 10 years ago was that Miss Blair told him CPS was called. She didn't give him details, and the agency can't fault Miss Blair for that, as the agency didn't bother to notify Mr. Berry at all. Mr. Berry knew that Gabrielle and Stoney and his son Stephen were not removed. They were still living with Miss Blair. Further, there's no evidence that Gabrielle or Stoney disclosed abuse or that the abuse from the 2005 substantiated referral was visible when wearing clothes. The 2005 referral is regarding marks on the girls' backs, areas covered by clothes. The children appeared fine, and he knew that Child Protective Services left the children in Miss Blair's care. Your Honor, the second time frame begins in October of 2010, when my client was arrested for felony firearm and weapons firearm. October of 2010 was Mr. Berry's last time in Miss Blair's home. At that time, Stephen is 7 years old and Matthew is 4. Matthew's too young for school, and the petitioner did not present any school records for Stephen prior to September of 2010, just 1 month before my client was incarcerated. The children showed no signs of abuse, they didn't disclose abuse, they looked healthy and well fed. Despite petitioner's counsel's erroneous math, which I know is unintentional, Mr. Berry was in fact detained and out of the community entirely from October of 2010 through March of 2013. Mr. Berry did try to make the best of his situation. He worked hard and obtained his GED while incarcerated. He learned job skills. He worked those jobs so he could earn enough money so as to send Christmas gifts to his boys. It was during this time that the unthinkable happened to Stephen. 22 months into Mr. Berry's sentence, in August of 2012, Ms. Blair killed Stephen. This was approximately 6 months before Mr. Berry's release. While Mr. Berry served his time and worked to make things better for himself and his boys upon his release, Ms. Blair took Stephen's life, stole Stephen from him, and in the most horrendous of ways. Ms. Blair admitted that no one but her and her 2 surviving children knew until the day of her arrest on March 25th of this year. The fact is that Gabrielle and Matthew were too afraid to tell anyone. Gabrielle indicated to medical personnel she was afraid for her life, and Matthew indicated in his Kids Talk interview he knew his mom that he wouldn't tell, that she didn't even have to instruct him. Your Honor, the third time frame begins in April of 2013, when my client is paroled to an apartment on Vinewood in Detroit for a year. He has only the clothes on his back and has reapplied for food stamps. He desperately looks for a job to support himself and his sons. He stays out of trouble with the law. He supports by giving food. He is unaware of a support order entered in 2007, and evidence corroborates this. The orders were entered by default. Further, as Mr. Berry was unaware of these orders, he never filed for an abatement for his obligation when he was incarcerated for 2.5 years. His testimony that he first becomes aware of the orders when his paychecks from Labor Ready are reduced for support in November and December of 2014 is credible. Labor Ready is a temporary agency that unfortunately has not had work for Mr. Berry since December of 2014. Nonetheless, Mr. Berry does continue to seek work regularly so as to support himself and pay support. After his release, Mr. Berry testified that he did see Matthew regularly. There's no evidence of desertion, Your Honor. He saw him at his home, and on each visit, Matthew had no visible marks. He appeared healthy, well-fed, and unafraid. Matthew never tells Mr. Berry that he was being hit. He doesn't tell him about what happened to his brother or Stoney, or that Gabrielle was being hit. He tells Mr. Berry what Miss Blair wants him to, that everything is fine. Miss Blair is angry with Mr. Berry for being incarcerated and does not allow him in her house. She lies and says that Stephen did not want to see Mr. Berry because he had been gone so long due to his incarceration. In fact, Miss Blair lied to everyone and had Gabrielle and Matthew lie for her. While Miss Blair failed her children in the most ultimate of ways, she knew how to protect herself. She hid the bodies. She would not let the fathers in the home. She would not let Mr. Berry see Gabrielle. She told the school she was moving. She lied to her close friends by saying that Stoney and Stephen were upstairs because they didn't like company, or they're at an aunt's house, or they're at a cousin's home. Neither of Miss Blair's close friends, Victoria Johnson or DeJuan Martin, suspected anything. Miss Blair had her friends so trusting of her parental abilities that Miss Johnson and Mr. Martin made Miss Blair godmother to one of their children. They had Miss Blair care for overnight their 10-month-old son in Miss Blair's home the day of her arrest. And they were planning on having Miss Blair and her children move in with them upon her eviction that they knew was coming on the day of her arrest. Miss Blair protected her secret by abusing Matthew on his back and his bottom, areas she knew would be covered by clothing. She knew that her children were so afraid of her they would not tell anyone about the abuse. Your Honor, credibility of the parties is important for the court in deciding whether the petitioner met its burden of proof. Mr. Berry testified credibly with corroborating evidence. Neither Mr. Berry nor those closest to Miss Blair knew of Miss Blair being abusive, let alone killing her children. Petitioner, on the other hand, has little credibility regarding the allegations against Mr. Berry. The agency has been aware of Miss Blair's abusive behavior for 13 years. The petitioner admits in their report, quote, "The trend for this family appears to be physical abuse and physical neglect," unquote. Child Protective Services first substantiated a referral regarding physical abuse in 2002 regarding Gabrielle and Stoney, including illegal utilities and the children smelling of urine. The agency failed to file a petition with the court. They failed to seek court protection of Gabrielle and Stoney despite knowing of the abuse and having the power to file a petition. We can't even know what services Ms. Blair was offered or she complied, as the file was destroyed. CPS had not one but two prior referrals regarding Ms. Blair. In 2005, there was another substantiated referral regarding physical neglect on Gabrielle and Stoney, including, quote, "multiple linear marks on the backs of the girls, some old and some new. The girls weren't going to school regularly," unquote. Despite the substantiation, CPS again failed to protect the children by filing a petition seeking court protection of not only Gabrielle and Stoney this time, but Stephen, who was now almost 2 years old. They referred to Mr. Dorsey as the father of all three children. They never notified Mr. Berry of what was going on. The agency did offer Ms. Blair services. In fact, they kept the case open for an entire year, from February of 2005 to February of 2006. During that year, Ms. Blair either didn't comply with or benefit from the services offered. Therapy revealed that Ms. Blair was majorly depressed. She was hard to get a hold of by the workers. On one visit, the worker found that Ms. Blair had left Stephen, who wasn't even 2 years old at the time, home alone. They knew she still wasn't sending the girls to school. Ms. Blair said she went to court for that. She only attended 3 out of 15 classes they had sent her to. She missed 13 Work First referrals. The house was messy, the kids were unkempt. The worker wrote in a report signed in August of 2005 that the agency asked Ms. Blair to submit to a psych eval, and that, quote, "the case will remain open until the risk of harm to the children is low, and the mother has completed the psych eval," unquote. However, 6 months later, in a final report dated February 2006, 1 year after receiving the substantiated referral, the psych eval is mentioned, but there are no results and no proof that mother even went to the psych eval. And the worker states, quote, "this case is closing and the risk level is moderate," unquote. As the court knows, if a petition is filed and the court takes temporary wardship, the parents generally have up to a year to finish and benefit from their services. Or the court orders the agency to file a petition for permanent custody. While no one can predict what would have happened had CPS filed a petition on the first referral, or at any time during the year-long second referral, the petitioner's actions and inactions certainly call into question the agency's credibility to allege that Mr. Berry either knew or should have known about the abuse or could have prevented his son's death. The agency presented no evidence that Stephen and Matthew were abused at all prior to 2010. They admitted that they never notified Mr. Berry of the year-long 2005 referral regarding Mr. Dorsey's daughters. And when Mr. Berry was incarcerated and out of the community, his son Stephen was killed. Mr. Berry regularly visited with Matthew, who showed no signs of abuse and denied the abuse to himself or his siblings. It is incredulous of petitioner, whose sole reason for existence is to protect children, who had the knowledge and the power to file with the court on more than one occasion, to assert that Mr. Berry should have filed with the court, when the petitioner itself didn't think that the children needed court protection, despite having the knowledge that Mr. Berry did not. In summary, Your Honor, the petition has failed to prove abandonment, as Mr. Berry, its only witness that the petitioner called regarding him, indicated he did visit with his children, and he visited with Matthew on a regular basis after his incarceration. That the petitioner itself does not allege physical abuse of his children prior to his incarceration. That the petitioner admitted to not contacting Mr. Berry regarding the 2005 referral of Mr. Dorsey's children. That Stephen was killed by Miss Blair during Mr. Berry's incarceration. That Mr. Berry visited with Matthew regularly after his incarceration and saw no signs of abuse. That Matthew's marks were on his back and his bottom, areas covered by clothes. And Mr. Berry did provide food for his son Matthew. Mr. Berry does have income and housing issues, and for those reasons, we ask the court to take temporary jurisdiction of Matthew as it relates to Mr. Berry. We ask that a treatment plan be developed and the goal be reunification. Thank you.
Ms. Burns, I understand your client did wish to come in and confer with you and to be present for your closing.
To be present with my closing, yes, Your Honor. I would like her to be also.
So it's 12:30 now, so perhaps we'll take our lunch break.
If the court can bear with us, I would, since I think it would be more cohesive to complete now. I'm not going to be overly timely. I know the court knows me and I have a tendency to be verbose, but I'm not going to give one of my hour-long soliloquies.
We'll do that, and then we'll take our lunch break before decision. But we'll just take a 5-minute break, and then we'll just go off the record.
Thank you.
Kelly, you went both ways. I mean, when I had asked him that question.
Oh, probably all the time.
Then he came back and changed his testimony. So it's
Can't get too much down there.
I'm up there.